our activists out of NAN, and what does the law, the white supremacist law, say about all this freedom we're requesting?
Well, I can't say white supremacist law, but
That's right. Not yet. Not yet.
I can't. I don't. We exist, and I love the prophetic message. Minister
Ron McHenry, brother. Yep.
Okay,
Minister
yeah.
Ron. Yep.
Yeah, Pastor.
He's prophesying to me now.
All right.
Yeah, he's going to be.
I don't know the chain of command.
In the fullness of time. In the fullness of time.
I'm just a brother in the struggle.
Well, I mean, I think, again, from a legal perspective, I'm thinking about two cases. I'm thinking about first one being, Brown v. Board of Education,
Right.
and where the court got involved in saying that, segregation when it comes to children was an evil institution, because the court went and they did research with a doll, I believe, and it was a black doll and a white doll. And
Right.
I'm sure you guys know this already, but for the audience, the black children would choose the white doll as being preferable, and they were showing that segregation and the effect on children, that it made them feel less human. Another case that I'm thinking about in regards to why these types of cases are really hard to pursue, just instead of going from the constitutional route, but looking at something, looking at like a procedural issue, is one case called McCleary v. Evans, where there was a black woman who was applying for a job, and she said that while she was being interviewed, she felt as if she was just not treated fairly, and that she felt that interview was racist. And the court, the opposing counsel in their response to McEvans or to McCleary's case, said that they dismissed it on something called a 12B6 motion. This is really good for the audience to know. So if you're going something racist, you can know what this is, so you don't have to have a procedural issue. So she went and she made a claim, they were racist. The opposing counsel, the job, said that this is dismissed from a 12B6 motion because she didn't really state legal claim. She just said that she interpreted or she felt something racist occurred to her. What she should have done instead was really give the court details during the interview, for example, them scoffing or not looking at her. And that could help her case to be brought to a trial level. There's also something even deeper. Why we have to, when we have to make these claims, we have to go even further. The courts, when they're seeing whether or not a case should go from just being something that they're looking at to going to trial, or go with something they're looking at to go into discovery, which is where they're gathering evidence from the opposing counsel, the opposing party, is something called plausible and conceivable. So what that means is when you are bringing a claim to the court, and the court says, well, it's possible that this happened, which is conceivable, but it's not enough for something to be conceivable. It has to be something that you can infer from, that this evidence is strong enough where I can see exactly where this occurred, which is something that we call plausible. To go a little further, I'm sorry I'm going deeper in this, guys, but it's something you should know. This is based purely off of the judge's perspective. Now, from a legal realist point, which we can't make in court, right? Judges are usually white, and they're usually men. And so if you're telling a judge that you experience bigotry, and you expect them to understand it plausibly that what you're saying is true, you are more than likely going to get your case dismissed on a 12B6 motion, because the judge cannot understand fully where you're coming from. It's a white judge. How are they going to know what it means to undergo a microaggression when you're doing a job interview? So a lot of these cases are just thrown out. So just something to guard against, make sure that if you're making a claim against racial discrimination, you're being really in depth and in detail, and then on top of that, you know, make sure that your case is as plausible as possible. So put that out there. Thanks.
You know what I've learned today is the difference. We had 4 of us talk about how it is being black in America. I'm 81. Graham, so it's 74 now?
Just about.
Almost 74. And he's 35, and you're 24. So we had 4 generations talking here, how it is to be black in America. So that for our public, the Gilchrist experience. This is what we're doing here. And I treasure these moments because I'm going to bring to you another one of my heroes, Malcolm. And I want to play something where Malcolm had transformed himself. Play item 4, I think it is. 4? This is Malcolm at the end of his life, really, a month before.